Testing 1 2 3. Testing 1 2 3.
We are on the record. Good morning. Welcome to the Maryland Public Service Commission. In docket RM75, a rulemaking with respect to offshore wind regulations. By notice issued on August 2nd, 2022, this has been noticed as the time and place for this commission to convene a hearing on staff's petition that was filed on November 16th, 2021. Comments and response were filed on December 7th, 2021. For those of you who recall, on December 21st of 2021, the Commission held a hearing, and I recommended that the hearing be postponed due to possible legislative changes, and the Commission directed staff to file new regulatory text on May 4th. A number of extensions were granted to June 6th and August 4th, and at which time a staff report was filed. Responsive comments were filed on August 8th, and the commissioners have reviewed all of those pleadings that were filed in RM75. At this time, we will take appearances from the parties from either the table or the podium. We will begin with the appearance of staff counsel.
Good morning, Chairman, Commissioners. Michael Dean on behalf of the staff. I'd also like to enter the appearance of Lloyd Spivak.
Thank you, Mr. Dean. Office of People's Counsel.
Good morning, Chairman and Commissioners. William Fields for the Office of People's Counsel. I'll also enter the appearance of Daria Pugh of my office, who's worked on this matter. Thank you.
Thank you, Mr. Fields. Counsel for Sierra Club.
Thank you, Chairman. Good morning, Commissioners. Susan Stevens Miller on behalf of Sierra Club.
Thank you, Ms. Miller. Counsel on behalf of U.S. Wind.
Good morning, Mr. Chairman and Commissioners. Carville Collins on behalf of U.S. Wind. And I'd like to enter the appearance also of a colleague, Annamieka Moore. Thank you.
Thank you, Mr. Carville. Counsel on behalf of Skipjack Offshore Energy.
Morning, Your Honor. Christopher Gunderson on behalf of the Skipjack.
Thank you, Mr. Gunderson. Mr. Carville Collins, yes. Sorry. I do that every time.
Good morning, Chairman and Commissioners. Beverly Sucker on behalf of BGE. I'd also enter the appearance of Jessica Reba.
Thank you, Ms. Sikora. Counsel for the Retail Energy Supply Association.
Good morning, Chairman, Commissioners. Eric Wallace with the law firm Green Herlocker on behalf of the Retail Energy Supply Association.
Thank you, Mr. Wallace. Does any other party wish to make an appearance today? Seeing none. We have about a dozen discrete areas to consider at today's hearing. We also have two documents before us that were filed by staff. We have a consolidated and annotated version of the proposed regulatory text, noted as attachment number 1. And we have a second document which has staff's recommended changes, noted as attachment 2. We will begin today by having a presentation by staff and then followed by any opening statements of the parties. Again, parties are free to approach either podium if they wish to make any contributions, and they will be recognized when they approach. So we'll begin with staff.
Thank you, Your Honor. Staff would first like to thank all the stakeholders that participated in trying to resolve all the different comments in the regulations. And when we filed our updated report on August 1 with the regulation revisions, we were notified that there was one additional change that needed to be made, and that's because the Governor's Office of Minority Affairs is now the Governor's Office of Small Minority and Women Business Affairs. So that's in 3 places in the regulations that change is made, and that's reflected in the version that's on the screen now. And that's the end of my opening work.
Thank you, Mr. Dean. At At this time, do any of the parties wish to make a brief opening statement? Seeing none. At this point, we'll have a discussion of the revisions. As I noted, we have about a dozen items. Mr. Dean, were you going to walk through these revisions with us?
I believe so.
Okay, I'll turn it back over to you.
The first change is in subtitle 610103, B, in the definitions used in the Renewable Energy Portfolio Standard Program. The initial one is at 1-2. The administrator definition was under discussion. However, staff recommends that the change here, which is to have a single administrator instead of two administrators for the projects, be deferred with the changes from Senate Bill 526, the next phase of the revisions to these regulations. The other changes to the definitions are mainly to add items that are currently in the statute. Going down to 6-6, local community was revised based on comments from Skipjack. And basically, we've just added definitions from the statute, and also round 1 and round 2 offshore wind projects.
Mr. Dean, could you go back up a little bit, please? Community Benefits Association. Local community means a municipality or community of the state of Maryland. Does that include a county? Could it be a county government? Not just a municipality or a smaller community? Because, most of Maryland's local government, we have 130 some municipalities in the state, but our chief form of local government in most of the state is the county level government, is the local predominant form of government.
Well, part of the definition would be an entity which entered into a community benefit agreement. And I could say that it wasn't discussed whether it could be a county, but I don't see why it couldn't be a county, assuming that
I just don't want to preclude counties. It's simply what I'm trying to ask here.
I think the definition, because of the title local community, other than local government, by using local community, that's why the definition was made as it is.
Yeah.
Since some local communities don't actually have an official government.
They do, a county.
Okay.
I mean, a municipality does. I would it hurt to add county in here, or is it too late for that? I'm not trying to split hairs on this, but I want to make sure that counties aren't excluded for reaching into these benefits.
Well, there's no reason why we couldn't reword it to say municipality, community, or county.
If my colleagues would agree to that, I think it's clarification.
Mr. Chairman, and Commissioner O'Donnell, I'm fine with that modification, but I would suggest that there may be another location somewhere else in Comar where we've tackled this same issue before. I'm trying to remember where, and I suspect it's in there, so there might be another definition you can just use to capture Commissioner O'Donnell's concern.
Well, we can certainly take another review of the regulations.
Sorry. Municipalities are subordinate to the county. Okay. That's what comes to my mind, but it's open to interpretation. Could be a community of interest.
Mr. Dean, why don't we proceed, and perhaps the attorneys back at home office who are watching this can do a little research to see if they can't find that regulation that Commissioner Linton is thinking about.
Your Honor?
And just as a matter of fact here today, we do have the consolidated attachment 1 on the screen. I understand that both wind developers do not object to any of the staff recommendations. If that's not true, the wind developers should correct me. Additionally, I understand that Mr. Wallace, your client, doesn't object to any of the staff recommendations as well. Is that correct?
Yes, Your Honor.
Okay, you're making it easy on us today. We do have a few issues outstanding that I know that Sierra Club and Office of People's Counsel would like to address, and we'll get to those in due course. So, Mr. Dean, if you're okay, we'll move forward. We made a note to include community or a cite to the appropriate county, not community. Thank you, Commissioner.
Thank you, Your Honor. Going to the next chapter, Chapter 201 is a correction of a typo. Next, 2061-0203, again, correction of a typo here, the wrong terminology. $2061-0501. This is inclusion of a reference to receipt of grants for workforce development programs that's listed in the statute. And adding job training and workforce development as a evaluation criteria.
Thank you, Mr. Dean. And just a reminder to the parties, as well as to commissioners, as we move forward with your recitation of these proposed regulations, parties that wish to have any comment or commissioners having any comment, please use this opportunity. We will not be going back in time and starting over. So if you have an issue with respect to the proposed regs that Mr. Dean is going through, now is the time to make your case.
Mr. Chairman, I found it.
You found it. Okay. You saved staff council some legwork.
Yeah, I didn't want us to go too far away from it. It's Comar 20.31.01.02. The wording used there is local government. It's section, B12. Local government has the meaning stated in State Government Article, Section 11-101G, Annotated Code of Maryland. So you may have to change the wording from community to local government, but that gives you a definition that works in the statute.
Probably a cleaner way to clarify.
Thank you, Chair. I believe local government's probably in the statute also.
It is.
Going to the next chapter, 2061-0601. During the recent review process, we received text from MEA on proposed changes to the how an application is processed, and most of this is designed to ensure that parties are notified early on of what's happening, and so that they can get contracts for consultants and start the review of applications at an earlier process. And later on, deletions are occurring in the regulations mainly because it's being moved up to Section B. At the new C3 and 4, this change was recommended by the Office of People's Counsel, and it allows copies of applications to be distributed earlier, and notes that the statutory provision on not divulging confidential material would also apply to these applications. At F, this suggests that the commission would set a date whereby projects would revise their applications for any changes to the, essentially to the OREC schedules and other criteria prior to the start of hearings. This was initially reviewed at the last rulemaking session, and staff did not recommend this change based on the discussion from the rulemaking session. However, the Office of People's Counsel in their recent filing restated that they wish to pursue Section F again.
Thank you. At this time, we'll hear from Office of People's Counsel.
Thank you, Your Honor. William Fields for the Office of People's Counsel. That's right. This was discussed at the previous hearing, and there was some hesitancy. I'll just say, and this is not meant to be, we don't think this provision is a big deal one way or the other. Our motivation was just to allow the commission's consultant to do a review, publish something, reviewing any updates to any revisions to the developers' proposals, and allow that to be presented in an orderly fashion to the commission and to the other parties. Our intention was not to prevent developers from revising their proposals. They could revise them a second time during the hearing if that's what they wanted to do, and certainly not to prevent the commission from considering any additional revisions to the proposals. So that was our motivation for putting this forward. We think it's a benefit. It would be a benefit to allow the consultants to take a look at the proposal and update whatever analysis they've done and present that to everybody either at the beginning of the hearing or prior to the hearing, so folks know where everything stands as we go through the hearing. So that's and I'll just say this is the only provision where we have a difference with staff at this point, just to follow along with what you were going with earlier, Chairman. So that's really all we have to say about that, and I'd be happy to answer any questions.
Mr. Fields, let me ask you, I appreciate your discussion of your intention, because it kind of makes sense to me to get early information on revisions prior to the proceedings, hearings taking place. But could this be misinterpreted by future commissions and future litigants to be used as a way to say, you had your shot, you had to do it 7 days prior to the date set by the commission and don't come later? Because I can foresee a scenario, the first two tranches, we had revisions to the applications that I found to be beneficial. I thought they were good and competitive forces kicked in and it inured to the public's benefit. But I can see an instance where a revision may come in that may go the other way. And this provision, if we were to enact it, might be pointed to and say, oh no, too late. You had your shot. It's prohibited by COMAR. You can't come in now and revise it. Notwithstanding your explanation here today.
Well, as you just said, that's not the intent. I'm looking at the wording to see if there's a way to to indicate that this would not be the only opportunity. It says the applicant will have the opportunity to file revisions. I suppose you could add a sentence that says this is this opportunity does not preclude what word are we using? Applicant, I guess. This provision does not preclude applicants from filing further revisions to their proposals. Something like that.
Yeah, it just seems like contradictory. You got to file 7 days by the date set by the commission, but you can file anytime you want. I don't get it.
Commissioner Linton.
Thank you, Mr. Chairman. So, Mr. Fields, couldn't this same result be achieved at the actual hearing, where a party would simply just request leave to review, or leave to, if the consultant needs time, that they would just request leave to review whatever changes have been proposed?
Certainly, parties or the commission on its own motion could change the hearing schedule and push the hearing back. That certainly parties, like I said, or the commission could make that motion. It's a little difficult with schedules and just getting everybody together. So the goal was to set up a process where developers could take advantage of this at a particular time, and maybe an advantage to both of them doing that at the same time, pursuant to some date set up by the commission. But you're certainly right that if there was an issue, that could be attempt to be addressed at the hearing itself.
So if the consultant, how would we approach this if the consultant is able to review the changes that have been proposed and then concludes that they don't need additional time, that the changes don't impact any of their recommendations to the commission.
Well, that could be communicated to the parties. Letter could be filed in the docket between this, 7 business days, 7 calendar days, sorry, prior to the hearing. Between that and the hearing, that could be filed as a letter, and then everyone would know going into the hearing that the consultant had reviewed it and was not going to change their analysis or recommendations, when they got on the stand at the hearing. But if they did want to update something, then they could hopefully file something in the docket prior to that, and then people would see it, and the commission would see it, and know what was coming at the hearing itself.
All right, thank you. Thank you, Mr. Chairman.
Thank you. Commissioner Richard.
Yeah, thank you. As Commissioner O'Donnell pointed out, I mean, we've been able, in the course of these hearings, to actually discuss some of the issues and actually encourage the competitiveness of the applicants to actually, I believe, also improve the offering, and which was for the benefit of ratepayers. So I do have some concerns that if we shut that off, that in the future that we may not have that type of an opportunity. But to Commissioner Linton's point, is there some other opportunity to provide the types of transparency and further analysis that I think OPC rightfully would like to see happen, but maybe do so in a limited time that hopefully wouldn't step on. Sorry, I'm not sure what happened to my voice here. Would not step on the schedule. I mean, how much extra time would be needed, do you think, for this analysis? Because generally, I don't think it was any. At least our experience to date have been really that radical of changes. But there was an opportunity, I think, provided in the course of before a decision was made to do that type of analysis. So, again, I just wanted to find out if there's something we can do. And then I guess the second part of that question, I believe there is going to be another phase of the rulemaking for this. And so is there anything that you foresee coming in the near term that maybe might allow us to put this issue off maybe to a later phase in rulemaking?
Yeah, I don't know that it would be related to the phase dealing with the utilities, billing the ORECs.
Right, but it still would be a reopening of the regulations.
Right. To try to answer your earlier question, I don't, disagree that in the previous cases, developers have made updates to their proposals. The consultant has looked at it. There's been testimony, and it's all been considered. I suppose an alternative would be that, to acknowledge that parties may ask for a few days in the middle of the hearing to review, review the analysis. I'm thinking particularly of the ratepayer impact analysis. In the situations we've had, there really wasn't a lot of controversy about that. They updated their the consultant updated their analysis, ran new numbers. Maybe people didn't always agree with how they did it, but they understood how they did it. But in another, it's hard to say without, we don't have the proposals, we don't have the revisions, we don't know how the consultants are looking at things. It's awful hard to say how long that might take. The idea of 7 calendar days was to give some time without, really delaying. This wouldn't be delaying things. It would be done before the hearing started. An alternative might be, like I said, to have a recession of the hearing for a few days, and before the commission's consultant actually testified about this, if there was going to be a dispute about how they were revising their analysis or something like that. I'm struggling a little because it's hard to
Yeah.
hard to deal with all the possibilities, when we don't have a concrete situation in front of us.
Okay. Well, I appreciate that answer, and again, Mr. Chairman, I think I probably am inclined to, at this stage, support the staff proposal, but I would be interested to see if maybe OPC could develop this point a little more, and for perhaps in a second rulemaking or a follow-on rulemaking, to see if we can make sure that we do have all the analysis and information we need to make a final decision, because I think that's a valid point. I just would not want to tie the hands of the commission during a proceeding to the possibility of improving an offering. So with that, thank you, Mr. Chairman.
Commissioner Bubar.
Thank you. Thank you for describing the intent. I think that's actually it was really helpful to hear that. I do agree, though, that I think it's confusing, and we're struggling with trying to come up with some words that help clarify it. So I think it might be best to go with the staff recommendation. But I'm wondering if, in place of this proposed language, we come up with something that says if there is a need for additional time for further analysis, if revisions are made at the hearing, that time can be granted. But the commission has the ability to do that anyway, so I don't know that we have to state that. So I guess I'd be leaning towards going with the staff proposal.
Mr. Fields, in the most recent trial-type evidentiary hearing for round 2, did OPC request a continuance of the hearing to evaluate? No. Okay, thank you. Hearing no support for OPC's proposal. Mr. Dean.
Staff would note that we could always include a statement in the order setting the procedural schedule, noting the intent that projects update their applications, if possible, prior to the start of hearings.
Thank you. Hearing no majority support for OPC's proposed regulatory text, that text is rejected. Mr. Dean.
Yes, Your Honor. Going on to the next chapter, 2061-06-02, we're starting here adding information from the statutory changes. We've also got the correction of the state agency for the Governor's Office of Small Minority and Women Business Affairs in the sections at J2C and D, and also J9. At J5, or excuse me, J6, we had two sections recommended by Skipjack. Staff recommended using the first version, and that's included in the staff recommended Chromar change filing. And there's going down to...
Before you go down, can I ask you a question? Is MBE defined? And here's the reason I asked the question. Later down, under 6D, we talk industry for local residents, veterans, women, and minorities. So we had veterans in there, and I want to make sure that veterans are included, and I don't remember the construct of the MBE provisions for offshore wind. I know they were strong, statutorily And I know we're even alluding to veterans here, and there's been subsequent legislation that added MBE to minority outreach programs and diversity programs, even our own proceedings.
Yes, Your Honor, we added a definition, VSBEs, Veterans Small Business Enterprises, back in 03B18. And it's also consistent with the statute.
Okay, so if the original, at the beginning of this section of revisions, talks about minority business enterprises program, are VSBEs part of that?
Yes, Your Honor, they're included. And that's also with the statute at 7-704.1I, minority business enterprises.
Okay, fair enough. Thank you.
See, at Q, the Maryland Energy Administration had a recommendation on just changing the scheduling of dates, and that's also reflected in the staff recommended comments.
So, Mr. Dean, I just wanted to confirm that there's two periods of time here where the dates have been shortened, so that the application process is shortened to 30 days, and I'm assuming that includes the review period that is...
That's 30 days before the application submission.
Right. So the staff is comfortable that that's enough time for meeting with the local officials and everything else has to occur, that would normally have to occur during 60 days, is now 30?
Well, what would happen then, I assume, is that the application the application filing date would be pushed back until all the discussions had happened. In other words, it's
Okay.
not the prior date that gets changed, it's the later date that would need to fall back if the planning and scheduling had a mishap.
Okay, so they can just delay and potentially reach 60 anyway. All right, that's fine. Thank you.
Section S represents new text proposed by the Sierra Club on a proposed environmental mitigation plan. I believe one of the parties filed an objection to this inclusion.
Ms. Miller.
Thank you, Mr. Chairman. Good morning again, Commissioners. This is Susan Stevens Miller on behalf of Sierra Club. We made this proposal to ensure that the applicant's environmental mitigation plans are contained in the application itself. As this commission is aware, in the 2017 order and the most recent order, this commission actually adopted mitigation measures for things like pole driving restrictions and things like that. Now, the difficulty with that is that, as I'm sure the commission is aware, all this comes in piecemeal. Essentially, it comes in through bits of testimony, through cross-examination and things like that. And making the applicant file a mitigation plan up front would enable the commission and all the parties to see that plan as a cohesive whole and to analyze it as a cohesive whole. I'd like to address some of the objections raised by U.S. Wind. Essentially, U.S. Wind says that the federal government's going to take care of this. There's no need for this mitigation plan. But this commission has already decided with the mitigation measures it adopted that there are certain environmental issues that are too important to wait and see if the federal government agrees with the commission regarding their importance and regarding how to take care of them. So we're not suggesting that you have to do what BOEM does and do this large permit, but this lets you know the issues and lets you see, are there any issues that this commission should address and not wait the 4 or 5 years for BOEM to decide whether they agree with you or not. So that's an important point, that this commission actually has already decided that, yes, they would do that in certain issues. And this just puts the issues in one place so everyone can see them and everyone can address them up front rather than trying to pull this information from different places. U.S. Wind also objects because they say that it would not enable an applicant to use best available technology. We strongly disagree with that. The commission has addressed that in previous orders with regard to pole driving and things like that, to what technology to use or to use best available technology. Many federal statutes just refer to best available technology, that that's what you're required to use. So having a mitigation plan would not prevent any applicant from utilizing the best available technology at the time they intend to do whatever it is the commission has decided needs to be mitigated. The Sierra Club also objects to number 6, which is the monitoring provision. Now, we don't necessarily agree that they can't know some of what they're going to do for monitoring up front, particularly since this will be the 3rd round of applications and they've already filed BOEM applications and things like that. They can certainly put forth what they've proposed to do so far with other projects. And even if they don't know what they're going to do with regard to monitoring, they can say that. They can say, we can't tell you what we're going to do with monitoring, and these are the reasons why we can't tell you. So the idea that, first of all, we don't agree that they will have no idea how they're going to monitor, but even if that's going to be their position, they can just say that. And so we feel that this will be beneficial and make the process more efficient and make all the parties aware of what the environmental issues are, and quite frankly, have some environmental issues taken care of before it gets to hearing, because we can see what they're planning on doing, and we don't have to ask them questions about it. We know if we're comfortable with what they said they're going to do, that issue can be taken off the table, and hopefully when we see their mitigation plans, we can have conversations with them if we're uncomfortable with something and resolve those issues between us before it comes to the commission. So we feel that this will make it a much more efficient process and make the commission aware of issues and be able to better decide which issues they actually want to address themselves. Thank you.
Thank you, Ms. Miller. Questions from commissioners? Mr. Collins, would you like to respond?
Yes, Mr. Chairman, thank you. Carville Collins on behalf of U.S. Wind. U.S. Wind's concern is really one about timing. There is a very extensive federal process that will review all aspects of environmental remediation. Those reviews are going to be conducted under any one of a number of statutes, including the NEPA, the Marine Mammal Protection Act, the Endangered Species Act, the Migratory Bird Treaty Act, the Clean Air Act, the Clean Water Act, and Coastal Zone Management, just to name a few. Those reviews are going to take place in a much later stage than what the Commission here in Maryland is doing with regard to deciding on ORECs in the proceedings that it has had in case numbers 9431 and 9666. It's a much later process. There's very little that we know for certain about our environmental mitigation at this point. So the first concern that we have is that we would be asked to put together a plan long before we know it, long before we go through the real test, which is the permitting test, the permitting review. And that is what will be done at the federal level under those federal statutes. The second thing that concerns us is there in fact is already an existing regulation that COMAR contains requiring disclosure of extensive environmental information. It's a comprehensive environmental permitting and approval plan. So it's the plan for how it is you're going to go through the permitting and approval processes. That is 20.61.06.02 G paragraph number 11. And in our applications, in both cases, 9431 and 9666, we have followed that regulation very closely and provided extensive information in response to that call in that regulation. The third thing is that, many of the elements in this Sierra proposal, they are already addressed by the Commission in its final orders. The Commission has had no problem in making those determinations about things such as noise impacts and speed limit restrictions and pile driving, things of that nature. We've had discussion at the hearings where commissioners and other parties asked questions of our witnesses and asked questions of the other applicant as well about what were your plans to do that. That was fully vetted, and the Commission in both orders in 2017 and again more recently in last year covered those issues rather thoroughly, and we have very clear results and very clear guidance from the Commission in that regard. So really, the concern that we have is we're being asked to provide information that we just don't know, but will be thoroughly and comprehensively vetted at a subsequent stage in our review process. And for that reason, we have a concern for trying to front-end load this information in a very early proceeding called OREC application for the award of ORECs. We think that it is premature to call for such a comprehensive plan being filed in this process here in Maryland.
Thank you.
Happy to answer your question.
Mr. Collins, can I ask you a question?
Yes.
So the previous mitigation discussions during the previous two proceedings, or two tranches of awards, elicited a comprehensive discussion of these matters, and they were cited in our orders, and they were conditional on the approval. The companies agreed to those conditions. What would it hurt to be guided by those previous orders and stated up front, as Sierra Club's requesting, using those previous orders as a guide, because they were precedential? There's things we considered, things we discussed, and not just the two applicants here today, but any other applicants who may come along. Maybe other folks in the future, depending on what the feds do with regard to offshore lease space and what happens in the state legislature. What would it hurt to try to incorporate some of that guidance from our previous orders into your into any developer's application up front?
Well, I think, Commissioner, it's a great thought. That guidance will absolutely be part of what we would do if there were to be another proceeding, if there would be a round 3 or a round 4. It absolutely would govern us. It already is binding on us. It would be part of what we propose. But again, we would be getting into a situation where we're not yet at the BOEM. We're not yet at the National Marine Fisheries or at Fish and Wildlife Service. So we're not before those federal agencies, Interior or Commerce, yet. So we may have some information, and we may have some guidance from this commission. That will all be included. But we have not finalized it, and we have not prepared it in the context where it really gets the most strenuous test, which is the federal permitting test.
Yeah, but we have an obligation too. We have a statutory obligation to consider environmental mitigation. And if it weren't for questions from the bench and issues raised by other stakeholders during those previous proceedings, we wouldn't have gotten anything from the developers. And to me, it just seems common sense to say, give us something. Don't make us pull it out of you during the proceedings. We may miss something. So give us your thoughts up front, and then we can have that further discussion and meet our obligations. What's wrong with that?
Well, Commissioner, I respectfully submit that the commission does ask us for information.
I know, but we have to ask.
Well, it's in Comar.
Well-
It's in the regulation.
Well, it wasn't provided the last time. We didn't get to it until we asked about it, about pile driving, about air curtains, about right whales, about lights, about all manner of stuff. We didn't get to it until we asked about it,
But that,
notwithstanding that it's in regulation.
right. But that 0602 provision of Comar, that also becomes part of the checklist. So that became part of what we absolutely fulfilled. We fulfilled each criterion in that checklist, including this one, and we did file precisely in accordance with that 0602 regulation, requiring comprehensive environmental permitting and approval plans.
Yeah, but our conditional mitigation requirements in the orders we issued were not submitted up front. They came as a result of the proceedings, the litigation before us.
And I think, Commissioner, I mean, I think it's a fair point that in some situations, such as adverse noise impacts and efforts to minimize sounds and speed restrictions, those sorts of things, they can be decided, and the information can be forthcoming. But a number of other elements of Sierra's proposal here is calling for information that we don't know yet, we don't have.
Okay, can you tell us which ones are okay and which ones are not? Because seems to be some merit here, at least some merit, and instead of just wiping the whole thing out, tell us which provisions really are problematic, which specific provisions.
Well, I would submit that all of them are problematic in this regard, with the exception of the item 4, the noise impacts of pile driving, the item 5, the sound minimization in the various phases, and item 8, speed limit restrictions for vessels in the area. Again, we may not know this in final, but I think we have some sense of how it would work. So those areas would not be so objectionable, but the others would be, because we simply don't know. And here's the other consequence. If the commission were to approve that mitigation plan, and so that's the plan that the commission approves, but at a later, subsequent time, a federal agency comes along and approves a different mitigation plan, we're in a position of possibly not being able to comply with one of the other plans if they are in conflict. Again, it goes back to this timing issue. Do we want to sort of lock in with a mitigation plan that is approved here at the state level, and then have a subsequent plan reviewed and decided at the federal level with the possibility of conflict? We respectfully submit no. Let's go through what we consider to be a very exhaustive federal process before those various federal agencies and under those federal statutes that I've listed, and have our result there.
So let me ask you then to follow up. You didn't list number 2 as being acceptable. Proposed protections for critically endangered mammals such as the North Atlantic right whale, as well as other species that reside to transit the affected area, including protections from noise and vessel strikes. So that's unacceptable to you, even though the commission addressed that particular issue in our previous orders. And in those previous orders, it may still conflict with federal requirements of the NEPA, right? It's no different than what we have today, in my view. And I'm trying to elicit from you, I mean, conflicts can exist today with our existing orders with the feds. Probably will. But we have to meet our obligation too, right? And we've opined on some of these items that you didn't list. And that conflict may exist, may not exist, I don't know. But I don't think that's a showstopper, and I don't think we should jettison. I'm a states' rights kind of guy, right? I don't like the feds telling us what to do. I believe in the 10th Amendment to the Constitution, and I'm sure you do as well. Anything not delegated to the federal government or prohibited therefrom is reserved for the people in the states. That's our obligation, and under our constitutional system. So I'm not going to defer to the federal government. I'm not of that mindset, and I fail to see why I should genuflect in our federal system. Thank you, Mr. Chairman.
Commissioner Bubar.
Thank you. So it's interesting dialogue, and after having been in the federal government for 38 years, I've written, with the help of consultants, many environmental impact statements, so I know how detailed and comprehensive they can be, and I've written many records of decision. So maybe, Susan, I could ask you a question. I really am having trouble understanding where the efficiency comes in, because it does seem as if there would be some potential timing issues and duplication of effort, because the federal government is going to go through, per their statutory authority, such a detailed analysis and come up with a record of decision, which will stand in terms of what has to be done by the applicant. So I'm not clear, if this language is adopted, if the state comes up with something prior to that being done, where is the efficiency? Because there may be some confusion, there may be some timing issues, and so I wasn't really sure where the efficiency comes from.
Well, from a number of points. The commission has obviously decided in its two prior proceedings that it wants to look at certain environmental issues, but it doesn't know the whole gamut of environmental issues that exist with regard to offshore wind. This makes that part of their consideration more efficient, because it puts those issues in one place, what the companies recognize those issues are, and what they intend to do about them. I'm afraid I need to correct something Mr. Collins said. U.S. Wind has filed its permit with BOEM. We've commented on it. It has extensive environmental proposals in it. And certainly, if U.S. Wind files a third round of application, they can use what they filed with BOEM to make up this mitigation plan. Even if it hasn't been approved, they just have to say it's still before BOEM, but this is what we told BOEM we want to do. That's what the mitigations plan is supposed to be, to have issues out there that all the parties know about. I don't know if, Commissioner Bobar, you weren't here. If you recall, during the hearing, I was trying to, Skipjack had said that its O&M facilities would be net zero. And I was just trying to get someone to say that on the record. I had to go through 3 witnesses just to get someone to say that, and that was a good thing. That's why we wanted them to say it. So this idea that we can get all this out through testimony and cross-examination, it's not necessarily the most efficient way to get the information started. And so that's where the process becomes more efficient for the commission's view of what they should hear and what they want to hear about. With regard to the conflict with the feds, this commission addressed that in its orders, where it said that U.S. Wind or Skipjack is required to do A, unless what the federal government adopts is more stringent. And then you do what the feds say. And so it's not really an issue. The issue is, what information does the commission get up front so that everyone knows what the plans are of the companies? Everyone can essentially issue spot and see where they see a possible flaw and discuss it with the company. If they can't come to an agreement, bring it to the commission. But at this juncture, we're just kind of pulling out of the air different issues to present to the commission because we don't have the information from the company.
So maybe I don't truly understand the timing of when the information would be submitted to the federal government. So if we would agree to all this in terms of it having to be submitted to the commission, what would be the timing? So I don't know if who this is a question for.
I mean,
when that would come to the commission versus when it would go to the federal government. Because if it goes to the federal government, we're going to see it, right? I mean, it would also come.
It tends to go to the
commission.
federal government later. I mean, I know
Yeah.
all the permits previously have gone after they've received their OREC approval. And I was remiss in not stressing one other thing. This process is the commission's only opportunity to place any condition it wants. It won't see this again. It won't have another opportunity if it decides it should have done something because it hears about an issue later from another state that's doing it or something like that. That's another reason this is important, because this is your one opportunity to see all the issues and decide which ones are important enough for you to do something with.
Thank you.
Ms. Miller, I recognize that in recent years the state has effectively provided this commission with increased responsibilities with respect to environmental regulations. Notwithstanding, our primary purpose still remains being an economic regulator. Here you, on behalf of Sierra Club, propose these 10 requirements of a mitigation plan. But the Public Service Commission is not an environmental resource agency. We don't have dedicated staff that would be able to review a condition that could differentiate whether or not a vessel traveling at 12 knots versus 15 knots is the proper speed. And I could tell you that I would not be able to discern what would the proper speed of a vessel transiting through this area would be. As a former federal regulator yourself, you're very aware of the environmental impact statements that FERC produces pursuant to NEPA, and these are significant telephone book-sized documents where the federal agencies thoroughly review any environmental concerns here. Similar to Commissioner Bubar, I do have some concerns with respect to efficiency of our process to award the OREC. You noted that there were several environmental conditions that were imposed, although I believe they were largely consented to by the two wind developers at the time. Is my memory correct?
They were the commission issues its order and conditioned its order on acceptance of those conditions. So essentially what you're telling the companies is, if you don't like these conditions, you don't get your ORECs. So they agreed to them. I'm not saying there could have been one that was too onerous that they would have asked for a rehearing or said they couldn't agree to it. But that's the kind of process point at which they were conditioned. They did not agree to them before your order was issued.
I'm sympathetic to any environmental protections that we need to take, recognizing that the expertise will be handled at the federal level. How do I know that these 10 conditions are enough and the list should actually be 15 or 20? These are conditions that Sierra Club and Sierra Club alone have proposed to this commission today, and I lack the skill and expertise to detect if there are additional items that are not on this mitigation plan today. How would you respond to that? How do I know that sort of speed limits and emissions and restricting activities to daylight hours constitute the entire environmental package? Because each of these 10 items seem very different from each other.
Well, the straightforward answer is these gives you information. When next application proceeding starts, one thing you may realize is what information you still didn't get. And so at that point, either you can do through testimony and things like that, or update the regs for the next application process. There is no way to, I believe, create a list that could possibly cover the entire universe of any issue that might come up at any time in the future, but these are issues we know are out there. And we're not saying that my organization or any group couldn't raise another issue that wasn't in their environmental mitigation plan that we realized because of something that happened in Massachusetts. This isn't intended to be the universe. This is the universe we know of so far.
When we see the federal agencies under the dozen plus federal environmental statutes and we turn to that table of contents in the EIS, there will be more than 10 chapters, I suspect. And I suspect that the waterfront of these issues will be thoroughly considered. I am sympathetic to the concerns of Sierra Club, but the efficiency argument weighs heavy on me, and I think this is fully within the scope of responsibility for the federal environmental agencies if and when, years from now, these turbines are actually being constructed. Additional comments from commissioners. Commissioner Linton.
Thank you, Mr. Chairman. It seemed to me that there wasn't really a disagreement that the wind developers can at least provide some of this information at some point during the proceeding. Is that appropriate to say, Mr. Collins?
Yes, Commissioner, it is appropriate to say. Certain data points do become available, but I would say that an overwhelming majority of the data points are not yet developed. It's an ongoing process, and they are to be developed, and they are to be refined, and they are hopefully to be improved over time, a time period that does transpire subsequent to the OREC applications and the award of ORECs.
Okay, so it seems as though both parties, and I believe the staff as well, I haven't heard opposition to it, that are comfortable with the information being provided to the commission. It's just a question of when, either at the application period as the Sierra Club is proposing, or at a later point during the proceeding, or maybe sometime shortly before. Was this matter discussed during the work group sessions or prior to this hearing today as the regulations were being developed?
No, Your Honor, the timing of when they provided the information was not specifically discussed.
Okay. So do we know if there are other parties that would have any thoughts on this? I mean, People's Council or anybody else? Did they have any suggestions as to when the appropriate timing would be?
Thank you, Your Honor. William Fields for the Office of People's Counsel. We didn't have any objection to what Sierra Club was proposing here. Certainly, if information was not available at the application, at the time of the application, this regulation wouldn't prevent the applicant from saying that we don't know, we don't have that yet. We'll supplement it at some time during the hearing. But we saw a benefit to, at the outset of the proceeding, at the application, laying out the status of this information in the application, so that the process of discovery and discussing with the company could start based on that information. So that made the most sense to us.
That would be disingenuous because most of the stuff was in our previous orders.
That's all I can think of to say about that.
Okay, thank you. Well, I certainly would agree with the chairman to some extent that I don't know if this is, I guess as the lawyers, we don't know if this is everything that needs to be here or not. I don't have a concern about the commission obtaining the information. It appears as though it's just really a challenge as to when, and how, and making certain that the proceeding and eventually the order the commission gives is a well-written and efficient one, and it accomplishes whatever goals we've set at the time. I would have preferred to have heard from some of the other parties that might also have some interest in this information. I don't know if they had any thoughts on it at all, or if this is something that perhaps could be discussed at the next phase. I know it's not related to the main topics, but yeah, I had other questions related to it, but it really just appears to me as though it falls down just to the question of timing. And if the information is not available, it's just not available. not much more you can do about that. But I don't think it should preclude an application from proceeding, especially if we know the information will be provided or could be provided at a later date. But I also think Commissioner O'Donnell makes a good point that it's better for the information to be provided proactively as opposed to requiring that the parties have to ask and obtain it. So, thank you.
Commissioner Richard.
Yeah, I don't think we have any further questions to ask, but I do take Sierra Club's point. I mean, we have been given a responsibility by the legislature here to thoroughly review the applications for ORECs, which is something that will be paid by the citizens of Maryland, by the ratepayer. And I think we do have already demonstrated that we condition those ORECs on a number of items, many of them environmental. So I think I do see the point that this would be a very efficient process. Having learned from a couple of rounds of these applications, if we had this information up front, then it would certainly, I think, facilitate our decision-making at the hearing, and perhaps would allow us to go a little deeper into some of the questions, allow important parties like the people that Susan Miller represents to engage probably more effectively. So, yeah, and do I understand correctly, Mr. Dean, that staff has no objection to these to this language?
Staff did not object to the inclusion of the information. As you said, it appeared to be a matter of timing, but that was also based on no other party during our discussions raised an objection.
Well, I think the Sierra Club proposal, I think, would be an improvement to our application process, so I am supportive.
Commissioner Boer.
Just picking up, thank you, everybody. Thank you. Picking up on Commissioner Linton's points. Again, getting back to efficiency, this is Sierra Club's or Justice's recommendations, but it seems as if what to be included. But I'm not clear on how this relates to what the federal government is going to require to be looked at. So, I mean, there may be no disconnects. There may be more information. And as you had explained, Susan, this is the list now. The list may change as time goes on. And we haven't heard from any other parties as to whether this is the best and most comprehensive list at this point in time. So after listening and considering that, I do feel as if it's better to wait and think about this, get information from other parties as to whether this is the best list. But to Commissioner O'Donnell's point, there's nothing that is preventing us from asking for information from the applicants and requiring. But I still feel that at this point it's premature to include this because I feel as if it might cause some cycling and inefficiencies.
Mr. Chairman.
Commissioner.
So I really didn't state my position, but it's, I think, kind of obvious in as much as I think we've opined on most of this stuff, and future commissions will not have had the benefit that some of us have had to sit through the endless proceedings that we sat through and elicited the questions and had the discussions. I think it's more fair to put stuff that we've already opined on into the regulations so that any applicant in the future is treated the same. That's the purpose for rulemaking, and for that purpose I would be supportive of putting this in because it's ground we've already plowed. It's nothing new, and it's not intended to be a comprehensive list. And we've already gave a SOP to the NEPA process by saying if they come up with something more restrictive, that rules over any restrictions we put in. So.
At this time, for the record, we'll call a vote on the list proposed by the Sierra Club with respect to the 10 items in the list. So this is a yay or nay vote. The vote begins with Commissioner Bubar.
Nay.
Commissioner Linton.
Nay.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote nay. The proposal is rejected. Mr.
Mr.
Dean.
Chairman, could I ask a question? Can we do this without prejudice if the parties want to bring it back in a third round of rulemaking, that we state that this was rejected without prejudice because we had a split decision?
Always, yes. And there will be more rounds of rulemaking in this RM75 proceeding. Mr. Dean.
Yes, Your Honor. Moving on to the next chapter, 2061-06-03, evaluation criteria. These are mainly just changes to comply with the statute. From a prior question, I note that 03B 1A 14 notes engagement of small, women-owned, local, veteran-owned, and minority businesses. Just to note that the regulations do include those. At section E, there's just an update for the different items to be included in the commission order. Due to the recent statutory change. No parties commented on this.
Can we ask the question about C? The MOU shall include a provision whereby the applicant acknowledges that the commission or a third party designated, okay, I see it, or a third party designated by the commission may. So not anybody can go into the books. It's someone that, either us or someone that we designate. Is
Yes,
that
Your
right? Okay, I'm good. Thank you, Mr. Chairman.
Mr. Dean, just one other question. So we, obviously this is moving forward, or looking forward, but the commission currently has two memorandums signed with two offshore wind companies. And we'll be making a modification to COMAR that will apply prospectively. What impact does it have on the existing MOUs?
I believe the order already incorporated the audit provision. I would need to check to verify that though.
So are you suggesting, Mr. Dean, that, for example, proposed change C requires a third party that will audit or verify the applicant's expenditures, designated by the commission? So I don't believe that's in the current MOUs. I don't recall that being part of our most recent orders issuing ORECs. So I'm not opposed to it. I'm just trying to understand how it would impact existing MOUs for companies that are already receiving ORECs.
I'm afraid I'm going to have to get back to you on responding to that.
That's fine. Thank you. Thank you, Mr. Chairman.
Thank you. Mr. Dean, are we up to the research fund?
Yes, Your Honor. The next section was recommended by the Sierra Club Earth Justice. Staff added it to the end of 2061-0605 instead of adding it as a new regulation so that we wouldn't have to renumber everything afterwards. This was objected to by the filing by U.S. Wind.
Thank you. I see Ms. Miller at the podium. Ms. Miller.
Thank you, Mr. Chairman. Again, good morning, Commissioners. This fund was first raised at the recent proceeding on the U.S. Wind and Skipjack applications. It was my understanding at the time that a part of the Commission's hesitancy to approve something like this was that the applicants didn't know about it in advance. That it didn't come up until the hearings when our witnesses testified in favor of it, and as such, it kind of wasn't incorporated into their concept of their application. And so we've proposed it again, and what this fund is designed to do is to provide funding for research projects involving environmental and other issues associated with outdoor wind construction and operation. I think it's important to point out that this is a one-time fee, but that the monies can be used for the life of the facility. So we envision there would be pre-construction research, there would be construction research to examine the impacts construction has on different environmental issues, and then these facilities, it's my understanding, are going to operate for 20 or 25 years or more, and we've never had that. Anywhere in the United States have we had an offshore wind project operate for that length of time. So these funds could be used to say, after 10 years, are there issues that we didn't even realize would come up that we can now research to figure out how to mitigate them? And I want to stress again and again, we are using the word mitigate. Sierra Club strongly supports offshore wind. They want these projects to go ahead, but they want them to go ahead in the most reasonably environmentally protective fashion possible. And you can't do that without having research to know what the possible effects are. Now, the other issue that came up was that the companies are doing their own research and working with people. We are very concerned that companies who propose these projects and are making money off these projects are the ones who are going to decide what gets researched. So this is designed to complement their research. We don't want to duplicate their research, but this is designed to have another aspect of that research, a group of people who don't have necessarily a bias as to what they want to look at. I'm not saying their research itself will be biased, but what they want to look at, what they envision is important to look at, will be different from these other groups. So that's why we feel this fund is important and it would be beneficial to Maryland. Thank you.
Question.
Commissioner O'Donnell.
Ms. Miller, weren't there other reasons besides simply the fact that the developers didn't know about this ahead of time and it was proposed during proceedings? Because I recall having a lot of different concerns about this.
I'm sorry, I thought I mentioned at least one of the other reasons was that the companies were doing their own research.
There were a lot more than just that. Control the funds, administration, all the attendant things with creating these kind of different funds that we've seen. For instance, we had an issue with the Fuel Fund of Maryland with some funds that we provided through the merger and acquisition authorities that we have when we approved a merger, which became problematic. Not just the Fuel Fund of Maryland, but a lot of those beneficiaries of a well-intended but a nightmare with regard to administration.
And we certainly would not oppose these funds being held and distributed by a state agency, say an MEA. I can't volunteer them, obviously. Say an MEA, I would love to. Say an MEA or something like that, because they're also receiving, and the public's not, what research U.S. Wind and Skipjack are doing pursuant to your order. So they would know what research U.S. Wind and Skipjack are doing, so they could ensure if someone requests a grant that that's not duplicative of what's already being done. So we have no problem with, and MEA has extensive experience in processing grants.
Couldn't maybe UMCES, the University of Maryland Center for Environmental and Estuarine Services, undertake these kind of studies? They seem to work in this field all the time, and they have environmental centers around the state, in Solomon's, on the shore, in the mountains. They do a lot of this research anyway, so.
They could certainly do some of the research. I don't know that they do all the different issues, the Audubon issues and things like that. But it's still a matter of funding for them as well. They have to have the funding to do the specific research, and they get most of that funding, I believe, through grants themselves.
I get it, but it's just going to tend to increase the OREC costs, which we're already paying a very high premium for. There's no free lunch.
I don't disagree with that, sir, but I also think that you have to spend money sometimes to prevent harm elsewhere that would cost more money.
I am often reminded by my mother's admonition that the road to somewhere south is paved with good intentions. So anyway, thank you, Mr. Chairman.
Mr. Collins, did you want to jump in before commissioners proceed?
Very briefly, Mr. Chairman and Commissioners, just to respond to Ms. Miller and to address the issue very briefly. We heard the Commission loud and clear in its order in this most recent OREC proceeding. In order number 911-90011, the charge was quite clear. And the strong encouragement was noted that we would be not only committing to environmental research, but we would be reporting to the MEA on a regular basis. Another report has been made today, because we were right today at the 6-month period, so a copy of that report will be filed with the Commission later today. And we took the guidance and the very strong sentiment in the Commission's order to heart. We have made our own commitment. It's an 8-year monitoring commitment, and it is with the University of Maryland Center for Environmental Studies. We're not dictating what the research is. We're not dictating or prescribing what will be researched and what will not. We are putting together a comprehensive monitoring program for the entire lease area. And we will monitor all activities in conjunction with the UMCES organization as part of our 8-year commitment. That commitment includes significant funding. The amount of funding is approximately equal to what is proposed by Sierra. It's almost the same amount. So we have actually done exactly what Sierra has called for, but we've already done it. We've done it with a university-based academic institution, and it is research that is being done as a partnership, not being prescribed or dictated by us. It's monitoring that will be done throughout our lease area. And for those reasons, we oppose this proposal.
Commissioner Bubar.
I was just wondering if, with all the recent activities at the federal level, if there are any, I know these are local issues, but are there any federal funds that are now being provided for this type of research?
My recollection of the Infrastructure Act and the recent IRA is that it did not have funding for environmental research and those aspects that this fund would cover.
Thank you.
Commissioner Richard.
Thank you, Chairman. Mr. Collins, I think you already answered the question, but you said at this point your company or the company you represent is already contributing equivalent of $10,000 per megawatt. Is that the amount that you stated?
Roughly. Approximately, when you look at the megawatts and ORECs awarded in this most recent proceeding, the total cost of our 8-year commitment is in the neighborhood of that same figure, yes.
And I think we have a representative from Skipjack. Is that something you might be able to answer as well? I mean, I'm just curious how close we are at this point on the voluntary basis to achieving that $10,000 per megawatt contribution to research.
Yeah, thank you, Your Honor. I don't know. I don't have that information with me right now. I did have another comment on this proposal, but to answer your question, I don't know.
Okay, well, maybe I can just ask, does that seem like a reasonable amount? I'm just trying to understand it, maybe where that number came from, and I was going to ask Ms. Miller that as well, but is that seem like a correct amount that at this stage of the process, particularly since we're looking at a construction development that at some point I think the goal is 30 to 50 gigawatts of offshore wind. So I mean at this stage I think the point that Sierra Club is trying to make is we need to make sure we're doing it right from the start. So is that, do you believe, and maybe you can ask Mr. Collins as well, is that the correct amount that should be allotted for this effort?
To be honest, we haven't taken a position on what a correct amount would be. We don't think that this is an appropriate topic for rulemaking, however.
Okay. Well, I was going to ask, I mean, at this point, there have been commitments made by the companies to do this, to expend funding for research. I mean, is there harm at all to make sure this is coordinated through a state agency like MEA, and that just to memorialize this at the very beginning of the process, particularly since your companies are asking the state for this special incentive, the OREC. I mean, why shouldn't the state expect that there be a contribution for this important research? And I'd ask both the companies that if you have an opinion on that statement.
Yeah, I mean, I think it does kind of lead into the comment I was going to make. In addition to the reasons that staff and U.S. Wind have articulated for why the commission should reject this recommended rule regulation.
Could you pull the microphone closer to you?
Yeah, sorry. It doesn't appear that Sierra Club's proposal is seeking to implement a statutory provision, which is what a rulemaking is for. And so it appears to us that Sierra Club is asking the commission to legislate as opposed to implement a legislation. So to the extent that, for example, the contribution to the Maryland Offshore Wind Business Development Fund is legislatively required. To the extent that any additional funding would be required, that should be done through a legislative act.
Okay.
And Commissioner, I don't know what the basis of 10,000 per megawatt is. I don't know if that is calculated or arbitrary. What is clear is that the commission considered this issue and made its findings and made it quite clear that there was to be an environmental research effort by U.S. Wind, by each of the developers. And there was to be a very strict reporting regimen for that on a periodic basis, and MEA would be the recipient of that information. And I believe that Skipjack and now also U.S. Wind is actually providing copies of exactly what has been submitted to MEA pursuant to the Commission's order. And again, our most recent report in that regard will be filed later today. So I think there is an existing structure for this. I don't know what the right number is in terms of how much of a commitment, but I would submit to you that U.S. Wind has made a substantial commitment in fulfillment of the spirit, the nature, and really the words of the Commission's order last fall. And we think that that is a course of action that we'll stay on. We're certainly going to stay on it for the next 8 years because we have made a commitment with UMCES. And we submit that resolves the issue. And to try to add a proposed regulation that now would lay another fee on top of that, we think would be especially unfair for those of us who've stepped up and made a commitment voluntarily.
first of all, the $10,000 a megawatt was not arbitrary. It's based on New York and New Jersey use the same $10,000 a megawatt, so we were mirroring their programs. Part of the reason we think this program is important is during the two proceedings, much was said about from U.S. Wind and Skipjack about making the commission a leader in offshore wind. We want to make the state of Maryland a leader in offshore wind research. We want it to be the place people come to for answers, and that's what this fund will do. Now, Mr. Collins has just said that today he's going to file what they provided to MEA. That's the first I heard of that, and one of our concerns is what they're paying and what they're doing has been totally opaque and totally lacked transparency. Mr. Collins couldn't even tell you today exactly how much he's spending, U.S. Wind is spending. So it's impossible to make a judgment as to whether this is actually functioning as it should when we're not being provided the information to address what's being done and who's doing it. So that's a concern, and if those reports start being seen and if those reports are detailed enough, then that may at least address that concern. But there still is a concern that two companies are selecting what will be researched. And I also want to stress, Mr. Collins says this fee is unfair. This fee won't be charged to U.S. Wind and Skipjack unless they submit another application. This is for the applicant. So it's not unfair to them at this juncture because they don't have to pay it.
Right. Thank you for that answer, and that's I think that's an important point you just made, that we're talking about where we're going to go into, in the future, what's going to be required in future applications, and I think you would agree that we have at this point have some precedent that there's an expectation of a contribution toward this important research, so that as a leader, we make sure that these developments are done in the most sensitive manner possible. It seems like generally, if I've heard correctly, this $10,000 per megawatt is what New Jersey is doing and New York is doing, and so it seems what I've heard today that is the correct amount, about the right amount. So I guess I would say I do support the Sierra Club proposal. I think it is good to put this in regulation. I understand, the point about, whether this should be done in statute. I believe it already has been done in statute. We've been given a lot of latitude at the commission, and we've been entrusted actually by the legislature to administer this OREC program in a manner that meets all the public interest requirements. One of those being in making sure that we have a positive impact in totality on the environment. So for those reasons, I do support the Sierra Club and their recommendation.
Commissioner Linden.
Thank you, Mr. Chairman. So Mr. Collins, is this the first report that has been filed with the MEA and eventually with the Commission?
Actually, an earlier report was made to the MEA, I believe, on February 15. That would have been our first report under the directive of the Commission's order. And then 6 months later, August 15, this will be our second report to MEA on our status, our activities, and our commitments for environmental research.
So as part of your reports and the list of current and planned research activities, did you develop that list in conjunction with MEA or with other organizations or entities that would have an interest in these issues?
Commissioner, I honestly don't know the answer to that question. I've not been involved in those discussions. I believe we have maintained an ongoing line of communication with MEA about our activities. We're not just reporting to them once every 6 months, but the extent of the research that we are currently engaged in and the research that we've committed to through CES, I do not know how much, if any, consultation occurred with MEA for that activity.
Thank you, Mr. Chairman. Thank you.
Thank you. Ms. Miller, you cited to New York and New Jersey as requiring the $10,000 payment requirement. Was that by statute, or did the utility regulator have that authority on its own to
My
required.
understanding is that the utility regulator on its own had the authority to do so.
So the New York State PSC and the New Jersey BPU.
That's correct. And I just want to point out that I believe the statute you all are operating under for offshore wind says that you can put in any condition you believe is in the public interest. So you would have authority to do this if you so choose.
Another country.
If you could please make an appearance.
Yes, good morning, Michelle Honig, Assistant Attorney General for the Maryland Energy Administration. I didn't enter an appearance earlier, but I want to now just to let the Commission know that MEA is present, Sam Byrne is present if there are any questions.
Right. Thank you, Ms. Honig. At this point, we will call a roll call of the... Oh, I'm sorry, Commissioner Bubar.
Yeah,
Actually, could we get an MEA? I didn't realize they were here, so.
Well, we can't force them to speak, and they're just making an appearance.
Can we invite them to maybe just let us know what the current position is on this fund? I believe during the application process, MEA supported this proposal, so.
Yes, during the application.
Mr. Byrne, if you could enter an appearance.
Oh, sorry. Sam Byrne with the Maryland Energy Administration. I'm an energy program manager. During the round 2 OREC reviews, yes, we did support a similar measure in our official testimony because we believe that the Commission has broad latitude to include such a measure as part of a requirement or condition of an OREC approval. As alluded to earlier by Skipjack's counsel, we aren't exactly sure whether or not this type of measure could be included in COMAR without statute or, I guess, a signaling from the Maryland General Assembly. Now, if the Commission were to do such a thing, we would really defer to you and your counsel.
Very interesting. Thank you, Mr. Byrne. Commissioner Richard, any additional questions for MEA?
No.
Commissioner Bubar.
Just a couple questions. I didn't think our order required that the reports that go to MEA also come to the Commission.
I can do it.
So
Or do it then.
It did
Don't
not.
matter.
It did not. Okay, that was one of my questions. And Mr. Collins, on the when you say the commitment that you have with UMCES, is maybe you answered this, but I don't remember. Is that through an MOU that you've signed with them, or do you know what form that commitment takes? And if there's any clarity you can provide in terms of, kind of how the process works in terms of how the research gets decided?
Yes, I can. We've actually signed an agreement, so it's in effect a contract, Commissioner, for 8 years of environmental monitoring that we are agreeing with UMCES to conduct. And so it's a binding commitment in the nature of a contract.
Are there annual dollar amounts associated with that? Do you know?
I do not know. I do not know. I can confirm also to your other point that yes, there is not a requirement in the order that the information that we submit periodically to MEA go to the Commission. We thought it would be a good idea to just inform the Commission of what we're doing. So it's for that reason that we'll be making a filing later today.
Okay, and does that mean the February report was not filed with the Commission?
That's correct. We followed the exact letter of the order back in February 15th for our first report. But in considering this and thinking about it and thinking about the rulemaking and just the Commission's general interest in these activities going forward now, we think it would be in the best interests of all the interested parties, including the environmental organizations, as well as the other stakeholders, to make this a filing, and we would copy all parties to the OREC proceeding, case number 9666.
Thank you.
Commissioner Linton.
Thank you, Mr. Chairman. I actually had a question for MEA. If it was only just one, hopefully. Mr. Collins has said that the first update was filed with MEA back in February. Of course, you'll get a second one today. What was MEA's response or reaction to it? Was it satisfactory to you? Did you have concerns?
So when we received that initial report back in February, I believe, my memory serves me correctly, we pulled in the Maryland Department of Natural Resources to review that report, and also had a meeting between U.S. Wind, MEA, and DNR on that report. And I believe DNR was happy with that initial report.
DNR was happy with it.
Yes.
Okay. And MEA?
We typically defer to DNR on environmental matters.
Okay. All right. Two questions, but thank you. Thank you, Mr. Chairman.
Commissioner Richard.
Mr. Dean, maybe you could help with this legal question about whether or not this is something we could put in COMAR. I don't have the statute in front of me, but I was operating under the assumption that the kind of that catch-all last anything else that the commission sees, is in the public interest, allowed us to have such a requirement. But I'd be interested to hear from you and your legal opinion.
Well, I did some research on the issue of adding a fund that would be contributed to, which is not listed in the statute. And I had a concern. The commission itself has a fund, a telecommunications fund, that there's a surcharge that the commission administers as part of its tariff authority. And the commission had, this happened about 10 years ago, and I tried to find records on it, and being a tariff change, a tariff change was hard to find for documentation. But the commission had been, since the federal government had through its appropriations authority had and direction had sometimes changed the levels of how this would be used. The commission at that time had added a cushion to the fund to cover any shortfalls, and for 2 years in a row, the General Assembly, looking for additional funds for other uses, had included in its budgetary authority, had just taken the extra cushion of funds and reapplied it to other measures. And I also found a case that I didn't bring with me, where another agency had added funds to, was it in its administration of the fund, had added funds as a cushion to that fund, which was not under the statute, and the General Assembly had reappropriated those funds also from their accounts. And not saying that anyone would suggest that in the future that the General Assembly might look at this fund as being a source of funds for reapplication. That was something I was somewhat concerned about, adding it to regulations but not being covered by a statute for a specific fund.
So am I hearing you correctly that you're not saying that we don't have the authority to create this fund, require this fund, that the applicants pay into this fund? You're just cautioning that the legislature could later take it for another purpose? I'm trying to understand the answer to my question.
That is what I'm trying to say, yes.
Okay. But your opinion is we do have the authority under the statute, under the offshore wind statute, that this would be one of those other public interests that the commission could find is warrants such a fund, and we have the legal authority to create such a fund.
Yes.
Okay, thank you. Does that comport with what Sierra Club, Ms.
Yes,
Wilson?
Mr. Richard, that comports with it, that you have the authority to do the fund under any condition.
Miss Miller, you need to bring the mic down. The court reporter can't hear you.
Or grow.
Do you want to state what you just stated?
Sure. We concur with staff that the commission has the authority under the OREC statute, under the broad provision that allows them to place conditions they view in the public interest to adopt a fund such as this.
Okay, and then I guess the final the stopgap would be AOR. I guess if they felt that that we had exceeded, that would be another place where the legislature could let us know that. Is that correct in the process? Okay. All right, great. Thank you, Mr. Chairman.
Thank you. At this time, we will call a vote on the proposal by Sierra Club to create a new MEA. You're late to the. You need to be ready to go. Ms. Honing.
Sorry, Commissioner. Mr. Byrne has some additional comments.
Okay, Mr. Byrne.
Apologies, and thank you. So we don't think that the creation of a new fund is necessary because back in 2012, through the Constellation Exelon merger order, the commission already created a fund in 2012 that was later moved as a subaccount of the Strategic Energy Investment Fund administered by MEA. That in the order is described as the Offshore Wind Generation Fund, and more or less it serves the exact purpose of the fund that's being discussed here today through the measure recommended by the Sierra Club.
Thank you, Mr. Byrne. So MEA is on record as opposing this fund, as proposed by Sierra Club.
Well, just so
Hold on.
I just want to understand.
Well, I need a.
These
Hold.
different funds,
Okay,
that's all.
hold on. I need a response from Mr. Byrne.
Oh, okay.
That was just a clarification.
Okay. Thank you, Commissioner.
Okay, so the Offshore Wind Impact Research Fund, the way it's described here, that would be a new fund.
As proposed by the Sierra Club, I understand this as a new fund. And as I mentioned, there's already one that exists within MEA that serves this exact purpose.
Ms. Miller, again, I don't know where the others are, but I mean, if we were to amend that to be the fund that,
If you were to amend that the fee collected from the offshore wind.
Ms. Miller, we can't hear you.
I'm sorry. If you were to amend that such that the fee that's paid by the approved applicant goes into that fund, we would be fine with that. Because
Okay.
I don't know that fund has much money left since it was done during the Constellation.
okay, but that would be, okay, well, I would then so move, then we amend the language to this fund that MEA has identified as an alternative to the creating a new fund.
Commissioner, with all due respect, this, in the last 30 seconds, we've been spending an hour on the fund proposed by Sierra Club, and now we hear just amend it and Sierra Club will be fine. I'm not going to entertain any such motion.
Well, wait a second,
today.
We didn't
What?
know till like 2/3 into the discussion that MEA was even here. So, I mean, what?
MEA is here. They're on record as saying this fund is not necessary.
Well, why can't we just take a vote? I think it's already going to be
Okay,
4-1 anyway, so
okay,
why don't you just,
let's take
why don't
a-
we just take the vote?
let's take a vote.
Let's take a
I think
vote.
it'll be fine.
Okay.
We would discuss amendments in the legislature for hours and then kill the bill.
Okay.
Right, no, I think I read the room. All I wanted to do is get it on record.
At this point, we will take a vote on Sierra Club's proposal for a new offshore wind impact research fund. The vote begins with Commissioner Bubar.
Nay.
Commissioner Linton.
Nay.
Commissioner Richard.
Aye, and I don't think that was the fund we were voting on, but in any case, I would be in favor of contributing to the MEA fund that currently exists.
Commissioner O'Donnell.
Mr. Chairman, I'm going to explain my vote after I vote. Nay. The reasons are several. One, it's consistent with my previous position and vote and concerns, and it's consistent with our previous orders, so my no vote has not changed on this. I have a lot of concerns. And I think this could be, if we were to memorialize this in COMARS, it could be a disincentive to additional applicants and therefore be counterproductive to additional competition. And if you recall our first proceeding, we had one applicant right up until almost the deadline, till the window closed, and then boom, we got a second application, which provided great competitive forces in those initial rounds. And I think that that was important. And I'd hate to put a barrier out there early by reducing those competitive forces at the onset. And then lastly, nothing precludes stakeholders from proposing this idea in future applications as it was before, and then the commission will be forced to make a decision then. But I'd hate to make that decision now inconsistent with my previous vote, so I vote no.
Consistent with commission precedent, I also vote no. The proposal that we just voted on, it's poorly written. It doesn't state who controls the fund. It doesn't state who administers the fund. We have a state agency in MEA stating that it would be in conflict with statute to create a new fund that through regulation. So for all these reasons, I vote no. The proposal fails. Mr. Dean.
Going on to the next section, 2061-0606, Section B was a possible typo in the referencing the annotated Maryland Code. I would also note that the Governor's Office of Minority Affairs is referenced in the first line there, and that'll have to be changed to the new name. And I also will verify that Section A doesn't also have that same change.
Thank you, Mr. Dean. Before we go on to the next sets of regulations in Chapter 6, I noted that a number of them, they implicate, Mr. Wallace, your client here. They're regulations number 8, 9, 11, 14, and 16. And there appears to be a consensus between the parties at the table and in the room to continue this to a further rulemaking. Is that correct, Mr. Dean?
Yes, Your Honor.
Okay, is that correct, Mr. Wallace?
Yes, Your Honor.
Okay. Mr. Wallace, would it be an efficient use of our time today to discuss any of these regulations, or do we just shelve them and address them in the next rulemaking?
Your Honor, I have a comment I'd like to highlight when we get to the final reporting regulation that's part of the scope of this proceeding. But with respect to the other provisions, I don't think we need to address those today.
Okay, I appreciate that. And we do have two more regulations that wouldn't fall into this bucket, including the reporting regulations in Regulation 18, as well as Regulation number 12. I don't see any objection from the other parties. So, Mr. Dean, why don't we skip ahead to Regulation number 12?
Yes, Your Honor. This is correction of a typo again. The word charged is changed charges. And then going to the last regulation then, 2061-0618, this just would list the reporting requirements, and we list a quarterly report.
Thank you. Mr. Wallace.
Yes, Your Honor. Chairman, Commissioners, RISA's really only comment here is on the point 5 there, including the current status of the commercial operation date for the projects in the quarterly reporting. This issue is important to RISA because the commercial operation date is the trigger for the OREC compliance obligation. With the adoption of the legislation this session shifting the compliance obligation to the utilities, which will be addressed at the next rulemaking phase, that materially moves much of that concern off the table for RISA. The one outstanding issue that we flagged in our comments that we filed last week is there's a question in interpreting the statute around the overall RPS obligation that still applies to retail suppliers. The Tier 1 obligation includes a carve-out for the offshore wind component. So to the extent, and the way that RISA interprets that is that the OREC purchases and retirements and the OREC obligation that is fulfilled by the utilities under the new legislation will count towards the overall Tier 1 that's applicable to those sales, so that customers of retail suppliers aren't effectively being charged twice. And so what I think this is still an important requirement for RISA, because we believe that the ORECs that will be purchased and retired as part of the OREC compliance obligation triggered on the commercial operation date will impact the the overall Tier 1 obligation for retail suppliers, and will be important to help them understand what their obligations will be as the OREC obligation comes into force upon commercial operation. And so we think it's important that the COD be part of the reporting and that be public information. And this is an issue that RISA and some individual suppliers have commented previously in some of the offshore wind dockets, but we think it's important to include that as a clear call out here in the regulations as well.
Thank you. Does staff, the developers, or any party have concerns or objection to RISA's proposal?
Staff, I reviewed this with our division, and we believe that ORECs should be subtracted from the Tier 1 requirements, but that doesn't need to be part of the regulations right now, but we're happy to bring it up for commission guidance on that.
Thank you, but you have no concern with the request that they provide the current status of the COD date?
We included that in the staff recommended changes.
Thank you. And I see no objection or concerns from other parties to this room, and none from the commissioners. We've completed our review of the proposed regulations today. At this point, do any commissioners have any final thoughts to share? Seeing none, and seeing no requests for parties to be recognized, I would move that we publish the revised regulations filed by staff in attachment number 2 in this docket on August 1st, 2022, as amended here today in the Maryland Register for Notice and Comment, subject to non-substantive changes necessary to conform to COMAR drafting requirements as follows. Title 20, Subtitle 61, Chapter 1, Regulation 3. Title 20, Subtitle 61, Chapter 2, Regulations 1 and 3. Title 20, Subtitle 61, Chapter 5, Regulation 1. And finally, Title 20, Subtitle 61, Chapter 6, Regulations 1, 2, 3, 6, 12, and 18. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner O'Donnell.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. With that, today's hearing is adjourned.